Mr. Brown.
Thank you, Your Honor. May it please the court, counsel, my name is Nick Brown and I represent Central Bank and Real Estate Owned in what boils down to a matter of first impression regarding participation agreements between banks in the state of Iowa. Central Bank signed an asset purchase agreement with Liberty Bank on or about October 1st, 2013. The underlying transaction closed on or about December 31st, 2013. In that transaction, Central Bank bought certain assets and assumed certain liabilities of Liberty Bank, which had undergone previous asset and liability sales to other banks in the preceding months. This was not a stock purchase agreement, but rather Central Bank and Liberty Bank negotiated an arm's length transaction for Central Bank to buy certain assets and assume certain liabilities only. The record shows that Central Bank bought a property owned by Liberty Bank, which was classified on the books as other property owned, which is a non-bank property, located in Dickinson County known as the Inn. Central Bank paid considerable value for said property, as shown in the record. Prior to the purchase of this property, Central Bank had abstracts continued and title opinions done. And those title opinions showed that there was clear legal title held by Liberty Bank FSB. There was no abstracting regarding any interest held by any other banks or the participating banks who make claim to the property.
Well, but you got a quitclaim deed, right?
We did. And the reason for that, I guess, was Liberty Bank, this was the last string in the sale of banks. Liberty Bank was going to be no more after this last sale. So a warranty deed, even under the asset purchase agreement, there was limited representations and warranties. Given that Liberty Bank would no longer be an entity, there was no warranties to seek.
Well, what you bought, whatever interest Liberty Bank had. I mean, that's what a quitclaim deed is. I mean, it says you bought whatever.
I agree with your assertion 100%, but the participating banks didn't. I mean, Liberty Bank still had complete title. If you look at the contract, it calls for
as between Liberty Bank and the participating bank, you're a stranger to that original participation transaction, I gather, and they use the so-called trust language. You know, they talk about. I mean, the language itself talks about the property is to be held, the note and loan documents in trust, I think, and the suggestion is that the note and the loan documents are being transferred as an undivided interest, including the note and loan document, by the language there. Now, tell me that's wrong. I mean,
I think, and respectfully, I do think that is wrong to the very last part you mentioned.
Okay.
I don't think that it says clearly in the agreement that legal title will be held by Liberty Bank.
Legal title.
Yes.
Yeah, sure. And as always in a participation agreement, and Liberty Bank is responsible as the kind of the main lender, if you will, in the participation agreement for enforcing it and so forth and so on. But it strikes me there's a fair amount of case law if you use this kind of magic language in your loan participation agreements. It's not a mere loan, but it's an undivided interest in the underlying property too.
And I think the Jefferson loan case that I cited in my brief differs on that. It says that if it is held in trust, as you articulated, that the beneficiary's right is to go after either the proceeds, which was paid by Central Bank to Liberty Bank, or the trustee, is what the Jefferson Savings and Loan case, which is a United States Court of Appeals case from 1968, does say. So our argument to that would be that the beneficiary under the trust agreement would therefore have to go after the proceeds, which they were contracted to do, or go after the trustee for wrongfully selling the property without consent by the participants.
I mean, you start out, as I read Article 9 nowadays, if you have a participation agreement that involves a sale of a participation interest, it's self-perfecting, it's automatically perfected. So that would tend to tell me that the participant banks, at least at the very beginning of the transaction in 2008, are protected. For you to win, at some point, they must have lost that perfected security interest. When did that security interest go away? At what step in these series of transactions?
They were perfected to the sense that they were they had a security interest in the payments received. The participation agreement, especially under the Ross case, which is a case that this court issued, cites that the participating banks are merely just a contracting party. So the security interest that they would have would be a security interest in and to the payments received by Liberty Bank for the benefit under the trust for the participating banks. I don't think the security interest eschews into the collateral documents. It eschews only to the payments received by Liberty Bank for the participating banks would be my answer to that. So I agree with you. They had a security interest into the payments and it never went away, but the security interest follows the payment from my client, Central Bank, to...
Position is they never had a secured position on the inn itself?
No, just to the payments, which I think is what the Ross case does go on to say.
So the Ross case, we held that the participating banks did not have minimum contacts with the state of Iowa. It was a jurisdictional decision. We held they lacked personal jurisdiction, but doesn't that support you by noting that they are kind of one step removed? It's the lead bank that was
Absolutely. I think the Ross case is a dispositive case in this, in this matter. I know it wasn't directly on point, as it was kind of a personal jurisdiction case more so than it was, the rights and the rights to a contract a participation agreement. But I do agree with you that the Ross case is dispositive on this case. Chief Justice Cady did write that opinion, and he wrote that the court recognizes a big difference between a participation agreement and an assignment. That a participation agreement has some elements of an assignment, but is not an assignment directly. It falls well short of the traditional concept of an assignment, is what he wrote, because it merely involves the right of an intangible right, which is kind of regarding where my security interest falls off regarding your question. Again, in that opinion, it was differentiated that an assignment transfers the entire right of a contract from the assigner to the assignee, so that the assignee not only assumes the benefits, but also the rights and remedies. Further, it goes on to say, importantly, a participation agreement does not give the participating bank control over the collection of the loan or the contract. Instead, they merely maintain a contractual relationship with the lead bank, which I think kind of supports some of the answers I've given to the questions that have been posed. Lastly, in that opinion, it says that a participating bank can only look to the lead bank for satisfaction of its claims. It can't eschew to the mortgage or to the security documents. It only has rights against the lead bank.
So your view is there isn't even a security interest that attached, let alone was perfected against the inn?
No, absolutely not. Yeah.
Because given this quick claim deed, if Liberty Bank was the other side of the transaction and your client was not a BFP because it took a quick claim deed, it might be sufficient if they show there was merely a security interest, even if it wasn't perfected, right?
I agree with you on that. But I don't think the case law calls for it. I don't think the contract calls for a security interest in and to the collateral. The contract falls silent as to any security. It does not have the language granting a security interest in and to the collateral. It merely mimics basically the Ross opinion, which says that, basically they're a contracting party and they have a right to payment. We talked about the legal title issue. Again, from the four corners of the document, I do believe that it says legal title isn't into Liberty Bank. I think any other purchaser, I know it would have been by warranty deed, but I think it's the exact same situation. I don't think, unless they can basically piggyback a security interest in into the mortgage or the underlying security documents, I don't see how legal title is any different than.
Let me ask you this.
Yeah.
I'm going to try and simplify it. Because you do have a quitclaim deed, and therefore it doesn't matter probably whether this security interest is perfected or not, doesn't it come down then just to the intent of the parties in the loan participation agreement?
Absolutely.
And that's the ballgame here. And if the intent of the parties was a mere loan, you win. On the other hand, the intent of the parties is an undivided interest in the note and the documents, you lose.
I agree with that, and I think the very first paragraph of this agreement, or the first whereas clause is, abundantly clear to that section. It says, originating bank has originated a loan which is more fully described on Exhibit A. It does not say it's giving them any interest in the note. It's basically describing the terms of the note of which they are participating. They don't describe granting any interest in that loan. They don't give them an undivided interest in that loan. Merely Exhibit A is describing what they are taking a participating interest in. So I think that is, the dispositive paragraph in this agreement. I think the entire agreement supports our position, but I think that position, that Exhibit A, not granting any undivided interest or granting any rights in and to the actual note or the security agreements there too, help make this dispositive. Again, kind of going back to the Ross case, the participating banks agreed to share in the benefit. They did not, and receive a pro rata payment from the borrower each and every time the payment was made. They did not agree to roll up their sleeves and kind of step into the shoes of the originating bank, as wherein they would have to enforce the rights under the loan documents, service the loan files, and ultimately perform a collection on the borrower. Instead, they remain entitled to receive a pro rata payment from the originating bank as that payment came due. I think ultimately that shows that what should have happened at the closing table is Liberty Bank should have made payment for the payment, should have shared in the payment Central Bank made for the inn with the participating banks. And I think that is ultimately what will happen.
Let me ask you about Section 9 of the participation agreement. There's some language that's of interest and talks about default, and then it indicates that the borrower, if the borrower is determined to be in fault under the loan documents executed, in such defaulted loan and in any of the security, therefore, shall be deemed rateably concurrent. What do you make of that language? I mean, it's a little obscure, I admit, but it is talking now about the security.
And that is the first, they never actually, it's capital S, but they never actually define what security is under this loan,
Oh, is that hard to figure out? I mean, you're right. I mean, listen, this language is it looks like it's kind of boilerplate from somebody's
it was very strange to read, and I kind of have it highlighted in this, it is strange. And I think that kind of is further indicating that it's kind of a piggyback onto the payment. Any payment under a default is going to be shared between.
And in any of the security. Let me put it to you this way, in real simple terms.
Yeah.
I'm just going to step back. This language is not what you ordinarily would expect to see in a mere loan document, I don't think. I would tell you, I think it's somewhat convoluted, and it's got trust language, and it talks about the note and the loan documents, and it's one of these, I suspect, legal document that was written years ago that the bank has traditionally used, probably. And so it's not entirely clear, but ordinarily a loan transaction, a mere loan transaction, wouldn't have this gobbledygook, I don't think.
And I think that's where you go to Section 10, the collection section. I think they're kind of overstepping each other. I think ultimately what happened was a collection action which falls into Section 10, which does not have kind of the convoluted language that you talk about. It basically gives the originating bank all the, the rights to kind of run the show, for lack of a better term, and basically share the payments it would receive under collection with the participating banks. So I think I agree, Section 9 is very oddly worded.
Let me try and, I'm also trying to understand what this original participation arrangement was. Would it be fair to say, or is it your position that, in essence, what Liberty Bank sold was an undivided interest in the payments, in the stream of payments, but not in the actual loan and promissory note and mortgage? Is that fair?
Yeah, and that's kind of what almost exactly what Judge Katie writes in the Ross opinion, or Justice Katie, I'm sorry. Loan participation, it's basically a solution to lending limits. So basically, what is happening is Liberty Bank can't make this loan it was a rather large loan from the beginning. That's not really clear in the record. but Liberty Bank couldn't write the entire loan, so they participated out this, and the participating banks aren't taking any, risk. They're not taking, they're just they're taking risk, but I guess they're not stepping into the shoes of the lead bank. They're basically agreeing to share in the benefit, which is the, the payments. So I agree with you, yes, they're agreeing to receive payments as they come into Liberty Bank. They're not agreeing to step in as an undivided interest in the loan. They're agreeing to receive payments is what this contract calls for, and I think is what the Ross case calls for.
Chief, could I ask one question? I know your time is up, but why would a bank enter into a participation agreement if it's unsecured? We're talking about obviously lots of money here, and if I'm one of the participating banks and I enter into one of these participation agreements, isn't it just fairly customary that I'm going to require some type of security for this? It just doesn't make sense to me from a business standpoint that a bank is going to, and I don't know what the figures are here, but I'm just going to throw out, if I'm going to be a participating bank for $100,000, I'm just going to go ahead and put it all in your hands and not expect that it's secured in any form or fashion?
You have a payment, you basically have a right to the payments received by the lead bank, which is secured on the underlying loan. So if the lead bank forecloses, they get title and sell it, you have security in the payment received by the lead bank when they sell the property. You don't have a right to go get the property or collect on the property under the Ross case, but you have a right, once the lead bank collects under that loan, to take 40% in this case of that payment once it's received by the lead bank. So you kind of are secured, sorry, can I keep going? So you kind of are secured in the sense that the lead bank is going to act in your best interest to receive the payment, and then your payment, you have a right to receive the payment once the lead bank receives it.
And did the banks in this case get their fair share of that then to participate in the sale of the inn then?
That hasn't been determined because instead of making claim to the payment Central Bank made to Liberty Bank, the participating banks made claim to the property rather than the payment made. So they still would have that recourse under contract law, I believe.
Okay,
Thank you for your time. Thank you.
Thank you, Mr. Brown. Mr. Knickrehm.
Thank you. May it please the court, counsel. I'm Craig Knickrehm, appearing on behalf of the so-called Appellee participant banks. I would like to start off, Your Honors, by having a discussion about the application of the Uniform Commercial Code to the facts of this case. Counsel for the appellant has referenced several cases decided before 1998. And in 1998, Article 9 of the Uniform Commercial Code was revised to specifically deal with payment intangibles and promissory notes. As I understood from the briefing, the appellant's primary argument is that there is no security agreement here, therefore there is no security interest in favor of the participant banks. It's a participant bank's position that there is indeed a security interest that was created, and that security interest was created in the loan. In other words, the note and the mortgage, which of necessity and by law, settled law, follows the note. So it's our position, if upon application of the Uniform Commercial Code to the facts of this case, the district court's decision must be upheld.
Your position is that you didn't just acquire a security interest in the stream of payments, but you actually acquired a security interest in the inn itself back in 2008 or 2009. Is that right?
That's correct, Your Honor. It's not a situation where it's a debtor-creditor between the participant bank and the lead bank. The participation agreement itself says that the lead bank sells to the participant bank a participation interest into the loan. So,
and that, of course, that begs the question of exactly what that means, right?
Well, I think if you look at what's going on here, we're purchasing a payment intangible, and under Article 9 of the Uniform Commercial Code, a security interest in a payment intangible is created when we buy that.
So if you're saying the security interest arises as a matter of law under the UCC and not as a matter of parties' intent.
That's correct, Your Honor. As I understood, the big complaint from the appellant in this case was there's no, quote, security agreement. There's no document entitled security agreement. There's no granting of a security interest, but it's our position that under the Uniform Commercial Code, that security interest arises automatically upon the purchase of a participation interest. And indeed, the comments to UCC Section 1-201 clearly indicates that an interest of a buyer of a payment intangible, which is a participation interest, in a transaction that's subject to Article 9 is defined as a security interest. And you go to the to UCC Section 9-102, and that defines a payment intangible as a general intangible and or under which the account debtor's principal obligation is a money or a monetary
But
obligation.
let me give you a hypothetical. I go out and I'm going to go buy a house, and I negotiate the deal with the seller, and then I come to the closing, and there's a release from the bank that holds the mortgage on the seller's mortgage. How do I know, under your theory, there isn't some that they didn't sell a participation in that loan, and that those people may still be able to claim an interest in the property?
Well, in that situation, you don't know, but that does not negate the participant bank's security interest in that property.
That seems kind of harsh. I mean, as between the parties, no problem. I mean, I get that. But as between someone who is not a party to that, I mean, the UCC ordinarily relies on actual or constructive notice, it seems to me. I mean, there's no filing here, of course. There's no public document to look at to find out the security interest in the participating banks. All there is a transaction for which I was not a party to, and that seems to run a little bit against what I would characterize as the notice philosophy of the UCC. Push back.
Well, Your Honor, looking at the facts of this case, what happened in this case from our position is we had a security interest in the note and the mortgage. There was essentially a foreclosure because the property was surrendered. So the property became essentially proceeds. So our security interest in the note and the mortgage basically translated into a security interest into the inn. In this case, the appellants acquired an interest in the inn via a quitclaim deed, meaning they are conclusively presumed to be on notice of all prior equities, including the prior equities of the participant banks. And I think aside from that, to assuage any concern about, whether this was all in the up and up, they did due diligence. The record reflects that. They knew about the participation agreements, and they knew about the interest of the participant banks in those participation agreements. So I would just respectfully point out that under the UCC, if you take a look at 1-201, which defines security interest, a security interest is sometimes actually an ownership interest. That section defines a security interest as including any interest of a buyer in a payment intangible. So as a matter of law, it's our position under the UCC, we had a security interest in the loan and in the mortgage, and then once that property collateralizing the mortgage was sold by Liberty Bank prior to the sale to the appellant here, the participant banks maintain their 40.52% interest in that property.
But you're talking in UCC 9309, it says a sale of a payment intangible is perfected upon attachment. But what you're saying here is that you actually got more than just a payment intangible. You got a payment intangible plus an interest in the loan and in the underlying collateral, right? Am I misunderstanding?
No, what we're suggesting is that the purchase of a payment intangible, the purchase of the participation interest, the payment intangible, created a security interest in the note and the mortgage. So now when Mr. Brown talks about we should stand in line and wait for our payments, well, that cow's left the barn. I mean, the properties.
But you're saying that the sale of the payment intangible gave you a security interest not just in the payment intangible, which is the stream of money, but also in
the loan documents,
the underlying
in the note and the
loan
mortgage.
and the collateral. And
Yes.
I don't read that in Article 9.
Well, Your Honor, if you go at it from the standpoint of common law as well, if you take a look at the asset restructuring case, which considered both the minority and the majority view, and sided with the majority view that a participating bank has an ownership interest in the loan and underlying collateral, not just the collections from the loan. And that's a Texas case that I think the reasoning of that case certainly applies here, and I think if we take a look at the case decided by this court, in re receivership of Mount Pleasant Bank and Trust, an Iowa case in 1995, it essentially, without even citing asset restructuring, in our opinion, adopts that majority view.
Let me set aside the legal argument under the UCC and focus on an intent argument based solely on the documents available that memorialize the transaction. Supposing I'm just looking at those documents and I'm looking to try and decide, is this a sale solely of loan proceeds, or does it involve an undivided interest in not only the loan proceeds but the note and the documents? Where do I come out based on studying solely the loan documents?
Well, if you take a look at Section 1 of the participation agreement, it states the originating bank hereby sells to a participating bank, and participating bank hereby purchases from originating bank a participation interest in this loan. So,
Well, that doesn't help you, I don't think. Participation interest in the loan might arguably be construed narrowly. I'm interested in making sure you have an undivided interest in what I might legally call the whole caboodle. And if I was looking solely at the documents, I mean, there's kind of a bipolar feature to it. Either you bought simply an interest in a stream of payments, or you bought an interest in the entire transaction. And I want to know, looking at the documents itself, where we fall if I ask that question.
I think, and I need to yield here because I've agreed to split time, but I think that's evident in the participation agreement. And with all due respect, I'm going to yield to Ms. Carlson, who represents the trustee. Thank you.
Thank you as well, Mr. Knickrehm. Ms. Carlson.
May it please the court? I'm Robin Carlson. I represent Timothy C. Hogan in his capacity as trustee of the Liberty Bank Liquidating Trust. To go back to the question that was just asked, if you look at the participation agreement, Section 1, hereby sells to participating bank, and participating bank hereby purchases from originating bank a participation interest as set forth on attached Exhibit A. If you go back to Exhibit A, and I am looking at page 213 in the appendix, it identifies the loan. It also identifies the collateral. And I think that is the answer to that. I think you get both. They were purchasing an interest in both. And Liberty Bank was selling an interest in both. I think there was a reference to Section 9 as well. Interest in the defaulted loan and in any of the security, therefore, shall be deemed ratably concurrent. I think that also answers the question. And before I get into what I had prepared, I want to address a couple of statements that were raised in the opening piece of the argument. Mr. Brown referred to the title opinion showing clear title, a reference that the participating banks did not show up in the chain of title, and that is accurate. But there is no question, if you look at page 722 of the appendix, there is no that Central Bank knew about the participations prior to the time it signed the purchase and assumption agreement. That document is email from September 13th, 2013, from John Brown, president of Central Bank, to other bank employees referencing the anticipated sale of the inn. And specific in that email, Mr. Brown says, I just talked to Daryl and Art at Liberty Bank, and there is a deal on the inn at, and he gives the anticipated purchase price. The next sentence says, all purchasing banks have agreed. September 13th. The purchase and assumption agreement was signed October 1st, weeks later. There's no question that they knew. There's also no question that they knew based on what was on the OREO sale tracking worksheet. There is a comment in there, and I believe that is at page 717 in the record, and it's very tiny, that notes Liberty's bank interest is 59.48%. They knew how the parties were treating this. They knew that Liberty Bank presumed that it had 59%, and as the court has noted, it can't sell more than it had. Central Bank knew what Liberty Bank was purporting to sell.
Does that stop, what you've just read, stop short of actual notice that the participating banks would continue to claim an interest in the physical collateral, the inn itself, when you just read that all participants agree, and then they assume that the only bank with on the title, Liberty, is selling and giving a quit claim? Should they have done more, or could they just assume there's not going to,
I think Central Bank could have asked for a warranty deed, but there isn't anything in the record that indicates that it did. And Mr. Brown talked about that and the reason that he believes that to be the case, but that's not in the record either.
If we took out this evidence of actual notice, where are we?
I think they're deemed to have constructive notice. And I think we can't take out actual notice. They had actual notice, and we know it. They had it before they ever entered the agreement.
Can you address the concern that I think would a natural concern? I'm hearing the colloquy with Justice Mansfield that somebody could go buy a home, assume they're getting clear title, a release of the mortgage, and then have some other lender show up and say, hey, I've got an interest in this property.
I think that's a little bit of a different animal, but I think the bottom line is if you're not getting a warranty deed, I think the buyer has to ask why. If you're getting if you're getting a quitclaim deed, then I think you're on notice that there may be other.
But that's a separate argument. I mean, your position is they had a perfected security interest in the inn upon entering into the participation agreements. At least that's
Right.
what I read your
Right.
briefs as saying. So even a warranty deed is not going to protect them. I mean, you might have a lawsuit against the bank, and it probably wouldn't be a warranty deed. The bank's going to just sign a release of the mortgage, right? They're just going to, that's all they're going to do. But it doesn't protect you against some unknown participant stepping in and saying they've got an interest in some of your property, right? It seems strange.
Well, maybe the issue is it's sort of a gap in Article 9, but I think Article 9 kind of backs into this and makes it pretty clear that purchase of a payment intangible creates a security interest. So, and I am out of time.
You may sum up your argument if you wish.
Okay. Well, the bottom line in this case, Your Honors, I think that Article 9, the UCC addresses this, answers this issue. The Ross case was raised. I think it does not appear from that opinion that this court was asked to analyze participation agreements under Article 9 of the UCC, and I think when the court does so, it becomes clear that a participation interest, when it was sold ownership in the loan and the collateral that secured that loan, and accordingly, the Liberty Bank was not able to convey any more than 59.48% of the interest it held in the inn at Okoboji. Thank you very much.
Thank you as well, Ms. Carlson. Mr. Brown, you may present your rebuttal.
Thank you, Your Honor. May it please the court, counsel, again. A few things I'd like to clear up regarding some questions that were asked and some comments made. I do believe there is different law, different statutes regarding a security interest in payment intangibles and a security interest in an underlying mortgage, security interest, things of that nature. So I don't think that by getting a security interest in a payment intangible, you automatically get a security interest in anything else you want to claim, such as a note, mortgage, security interest. I think there are even, very more specific, granting language regarding notes. I think, to have possession of the note, to be the holder of the note is ultimate. I believe at all times Liberty Bank was the holder of the note during the course of this transaction. Regarding Exhibit A, and I do believe this is poor drafting. In the first whereas clause, as we talked about before, the participation agreement describes what the note is. So what Liberty Bank is selling a participation interest in. That is the first half of the document, the first half of Exhibit A. Exhibit A is also again referenced later as it relates to the amount of the participation sold, which is what Ms. Carlson did reference. After the note is kind of described in the first half of Exhibit A, it goes on to talk about the amount of the participation, the total participation outstanding on this loan, and then the participation basis, which is a LIFO, last in, first out, distribution.
I just have a quick question. How do you get around the argument that, the bank Central was on notice of the fact that you are only buying 59% of the inn because that's all that the Liberty Savings Bank really had? How do you get around that fact? I know it may go both ways a little bit from that standpoint, but you understood, it sounds like, and I'll go back and look through the appendix as well, but it looks to me like you knew exactly what you were buying, which was only 59% of the assets, and you knew that somebody else owned the other 40% of that asset.
I would disagree with that in that the Ross case calls this a contract. Basically, this is under an asset purchase agreement, you're buying certain assets, assuming certain liabilities. This was a liability of Liberty Savings Bank, or Liberty Bank FSB. Central Bank didn't, it was never stated in the asset purchase agreement, which is part of the appendix, that Central Bank would agree to assume this liability. The reason it came up on September 13th was that Liberty Bank still was the title holder. They were basically holding this property for the benefit because the participating banks had a right to receive payments. So as a beneficiary trustee relationship, Liberty Bank did get the consent of the beneficiary of the participating banks to sell this property. That transaction ultimately never went through. But at all times, Central Bank was purchasing property and assuming certain liabilities. One liability they didn't assume was participation interest. As it relates to quitclaim deeds, this was not the only piece of property Central Bank assumed title to. I believe there was probably it's in the appendix, but upwards of 20, maybe even more.
It's your position that your response to the participants' argument is they may have put Central Bank on notice that they claimed an interest in the property, but at that point, legally, they didn't have one. Is that essentially what you're saying?
Yeah, they had a right to the payment received should the property be sold. So that's where their interest came in, is they had the right to the proceeds. If this September 13th transaction ultimately went through, Liberty Bank would have the right to receive the payments, but they didn't have the right into the actual real estate or the real property, would be my argument.
Okay, so, but I guess going back to my question, then Central Bank still just bought 59% of the asset.
I think Central Bank bought 100% because Liberty Bank owned 100%. They just had a right to share proceeds received when they sold 100% with the participating banks. So Liberty Bank could sell the entire property. The participating banks basically had an interest in the payments received, they didn't have any actual, right to the property, just to the payments received, which is a big difference, but I think that's the difference differentiated in the Ross case between an assignment and a participation agreement. Had this been assigned in a mortgage, in a mortgage assignment, basically in the scenario you guys gave, the title holder would know that, hey, somebody else is claiming an interest into this property. That's different in this case. They don't get a claim and interest into this property. They get a claim and interest to the proceeds. So then at the closing table, you're not questioning, are you buying 100% of the asset? Basically, the participating bank's recourse is to go after the lead bank in this case. I think that nicely summed up my argument. I appreciate your guys' time, and thank you.
Thank you as well, Mr. Brown. Central Bank then is now submitted, and we'll now hear the arguments in State versus Majors.